Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration.
So ito mga kaibigan, pakinggan natin itong statement ni Nicholas Kaufman, no? Kasi pinaliwanag niya dito, no, kung bakit sa tagal-tagal ni Digong sa pwesto niya mula mayor from 1988 hanggang naging presidente siya, bakit hindi siya kinasuhan? No? Bakit naghintay pa ng ilang taon para siya ay kasuhan? Pakinggan natin.
Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso understood that killing is what Duterte would have wanted. Or that they had no choice but to comply because that was what was expected of them by their handlers. Or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defence has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte, or even indicating his participation in or control over any one of the 49 incidents alleged in a document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents will not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was in addition wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33 inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Another one. Interviewee. At least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee. Yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Death Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, Thinking like a prosecutor, I would say that the reason why the prosecution has fixated...
Yun.
Now, I have racked my
Sa
brain
panahon ni
for many a
Aquino, mga
month
kaibigan, si
pondering
Digong,
one question.
mainit na kay Dilima.
If Rodrigo Duterte
Mainit na.
was so
Kahit nung
shamelessly
hindi
brazen
pa
as to
presidente
broadcast
si-
his murderous intent in public,
Hindi pa presidente si
ever
Pinoy.
since he was the mayor of Davao,
No, sa panahon pa lang
why
ni
did it
Arroyo,
take the ICC
si
prosecution
Dilima nasa
almost
Commission
4
on
years
Human Rights na.
to open an investigation
Napakainit niya kay Digong,
to Rodrigo Duterte,
di ba?
pulled his country
Tapos
out
nung
of the
naging
International
presidente
Criminal
si
Court?
Pinoy at siya ay
After
naging Secretary
Why
of,
did the ICC prosecution
Secretary of
not
Justice sa
just
DOJ,
save
siya yung
itself all
secretary
the
doon.
hassle
Ang
of its
grabe
jurisdictional
ang laki ng
problem?
kapangyarihan,
A
napaka-makapangyarihan
fundamental
ni
issue
Dilima noon, mga
that still
kaibigan.
plagues it and remains to be resolved by the appeals chamber. We won't
Makapangyarihan
talk
niya.
about that today,
Kita
obviously.
niyo yung Department of Justice
But
nung
why
panahon
did
ni
the
Rimulya.
prosecution
Napaka-makapangyarihan niya.
to initiate its
Diba?
official investigation
Napadala niya si
within
Digong sa
the
dahigi.
one-year
Pero
withdrawal
bakit
period,
hindi kinasuhan ni
especially
Dilima si
given the
Digong
fact that
nung
Mr.
siya ay nasa
Karim
kapangyarihan?
the victim's representative
No?
embedded in the
Bakit
role
sa
of
kanya
chief
lang
prosecutor
kinasuhan si Digong
had
nung
received judicial
sinasagasaan
authorization
ni
to
Digong
interview
yung mga
at least
politiko?
one of the criminal
Sinasagasaan
cooperating
ni Digong
witnesses
yung malalaking drug
substantiating the
lords.
crimes of the Davao
Bakit doon pa?
mayoral
Doon lang ang
period.
panahon. Tama itong
Well,
sinabi ni Kaufman.
For me at any rate,
No?
it didn't
Kung si
take too
Digong
long for the
talaga
penny
ay
to drop.
kriminal, sa
As I mentioned in my
pinatagal-tagal ng
opening
panahon,
statement,
bakit hindi siya
prosecution
nakasuhan noon?
knows that it is not enough
Bakit saka lang
simply
siya
to
nakasuhan
assert that
nung
Rodrigo
pinupolitika
Duterte
na siya?
said outrageous things
Di ba?
and that deaths occurred.
Tapos
And
yung
so, as a result,
yung
he must be
ebidensya lang
criminally
ng
responsible.
ebidensya lang ng prosecution
There is a requirement
No,
for what is called
ebidensya
a
lang
causal
nila.
nexus.
na kriminal si
The
Digong, ay
prosecution
yung
has to
lumalabas
show
sa bibig niya.
which one of Duterte's
Hindi naman
statements,
nila direktang
orders, or
maiuugnay
commands
yung lumalabas
given
sa
to a
bibig niya
specific
kumpara
individual
doon
who then went
saan
out,
mga namatay. Halimbawa,
pulled the
sinabi niya,
trigger,
o patayin
or
niya sila
communicated the
Kulapo
command
bukas, tapos
to someone else
kinabukasan namatay
who
sila
also went out
Kulapo.
and
Yun.
pulled the trigger, killing one
Pwede yung ikaso
of
kay
its
Digong,
78
wala namang maliliit eh.
identified victims.
Di ba?
That would have been
Talagang
the classical way
itong
to
investigasyong
prove
ito,
the
yung
causal
kasong
link
ito sa ICC, bayad na
between
to eh.
stuff
Bayad na
that
to
came
mga
out of
kaibigan.
Rodrigo
At
Duterte's mouth
there will be a time for
and the
reckoning.
deaths pertinent